Hello, everyone, and welcome back. Before we continue on, I will remind you once again that I am not a lawyer of any kind, nor am I certified to practice law in Vietnam. I'm just simply a foreigner from the United States who knows about the labor code. Now, we're going to go ahead and move on. Today, we're going to talk about crime and punishment. That's what I call this particular series within the labor code because it talks about disciplinary measures and, essentially what happens when you have to go before, your English center because of something you did or something they did or something like that. Now, let's go ahead and get started. Now, Article 122, Principles and Procedures for Taking Disciplinary Measures at Work. Clause 1. Disciplinary measures against an employee shall be taken in accordance with the following regulations. The employer is able to prove the employee's fault. The process is participated in by the representative organization of employees to which the employee is a member. If you're a part of a trade union or something like that, that applies to you. Now, Clause C, please pay attention to this. 122 Clause C, please write this down. The employee is physically present and has the right to defend him or herself and request a lawyer or the representative organization of employees to defend him or her. Yes, if anything happens, if a disciplinary meeting happens, you are allowed to be present physically and you do have the right to defend yourself. Now, if you can't defend yourself, you also have the right to hire a lawyer or representative organization of employees to defend you. If the employee is under 15 years of age, his or her parent or legal representative must be present, which actually is true. Now, moving on. But that doesn't apply to English centers, so yeah. The disciplinary process is recorded in writing. Please remember this as well, okay? Because I know a lot of English centers don't do this. Okay, so if it's recorded in writing, yeah, 9 out of 10 times it's not because no English center actually does that. So if it's not recorded in writing, that's considered a violation of the labor code. Clause 2. It's prohibited to impose more than one disciplinary measure for one violation of internal labor regulations. What this means is simple. If you commit one act against the internal labor regulations, they can only give you one disciplinary measure. That's it. They cannot give you more than one. So we'll talk about that later on. Clause 3. Where an employee commits multiple violations of internal labor regulations, he or she shall be subjected to the heaviest disciplinary measure for the most serious violation. One moment, please. All right, let's move on. Sorry, I had to take a small break. All right, so essentially what this means is that if you go ahead and commit multiple violations, then you get the heaviest violation for the most serious offense. So, yeah. We'll go ahead and move on because I think they should have written this in a different order, but it is what it is. Clause 4, please pay attention to this. No disciplinary measures shall be taken against an employee during the period when the employee is taking leave on account of illness or convalescence, or on other types of leave with the employer's consent. Please pay attention, with the employer's consent. Subclause B. The employee is being held under temporary custody or detention. If you got arrested, then they can't give you a disciplinary measure. The employee is waiting for verification and conclusion of the competent agency for acts of violation stipulated in Clause 1 and Clause 2, Article 125 of this Labor Code. So, yeah, Clause 1 and Clause 2, Article 125. Please pay attention to that. Now, Subclause D. The employee is pregnant, on maternal leave, or raising a child under 12 months of age. So, that means that if you're pregnant, for biological females, on maternal leave, and that includes men and women, or raising a child under 12 months of age, and that applies to anyone. So, Clause 5, no disciplinary measures shall be taken against an employee who commits a violation of internal labor regulations while suffering from the mental illness or another disease which causes the loss of consciousness, ability, or the loss of his or her behavior control. Does not apply to English teachers. I can tell you that does not apply to English teachers. Clause 6, the government shall provide for the principles and procedures for taking disciplinary measures at work. Moving on. Time limit for taking disciplinary measures at work. The time limit for taking disciplinary measures against a violation is 6 months from the date of the occurrence of the violation. The time limit for dealing with violations directly relating to finance, assets, and disclosure of technological or business secrets shall be 12 months. This means that they have up to 6 months to go ahead and discipline you for something you did. If they do it past the 6 months, it's no longer valid. That's what that means. Now, moving on. So, essentially, if it's like, disclosure, technological, business secrets, blah, 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 that'll be 12 months. So they have up to 12 months to discipline you for that. But again, that applies to like Raytheon Technologies and, Lockheed Martin and all that. If I talk too long, I start to cough. Still sick. All right, let's go ahead and move on. So, Clause 2. In case the time limit stipulated in this article expires or is shorter than 60 days when the period stipulated in Clause 4, Article 122 of this Labor Code expires, the former may be extended for up to 60 more days. But I think that would be only in certain circumstances. Clause 3. The employer shall issue a disciplinary decision within the period specified in Clause 1 and Clause 2 of this article. So yeah, Clause 1 and Clause 2, they will issue a disciplinary decision. Yep, still coughing. All right, so let's move on. Article 124, disciplinary measures. These are literally the only 4 things that your English center is allowed to do to you, or your employer in general. These are the only things they're allowed to do to you. They shall not do anything else. If they do, it's illegal, and they should be held accountable for it. First, reprimand. Either verbal, written, whatever. It could be in person or, through electronic means. They're not really specific there. Number 2, that's the next one up. Deferment of pay rise for up to 6 months. Whether you get monthly, bi-monthly, quarterly, or half yearly or annual pay raises, stuff like that. They can defer that up to 6 months if you keep messing up. Now, this Clause 3 only applies to, for English centers, like senior English teachers and up, basically, for the teacher side. Demotion. Now, normally a regular English teacher cannot be demoted because there's nothing below an English teacher besides TA, and TAs can only be staffed by local people. That's it. So this would not apply to a regular English teacher. It would only apply to a senior English teacher, which could then be demoted to a regular English teacher. But if that same English teacher, let's just say, keeps messing up, then number 4 is the final straw, and that is dismissal. Now, for regular English teachers, it would be 1, possibly 2, depending, and 4. That's it. No number 3. So, Article 125. Remember, earlier, Clause 1 and Clause 2 must wait for a decision from competent authorities on Clause 1 and Clause 2 of this. Now, let's move on. An employer may dismiss an employee for disciplinary reasons in the following circumstances. Clause 1. The employee commits an act of theft, embezzlement, gambling, deliberate infliction of injuries, or uses drugs at the workplace. Now, here's the thing, folks. If an employee is caught in an act of theft, then, yeah, they should be dismissed. They should be dismissed for theft because theft shouldn't be tolerated anywhere. See, with me, I don't have very much, but everything I do have, I've earned. And a lot of people would not be proud of a 2013 Honda, but I'm very, very proud of it because I worked hard for it, I saved up for it, I earned it. That's why I love that bike so much. Now, the other thing, embezzlement. This normally applies to, say, the accountant of the English center or business because they're stealing money from the company for themselves. Could also be bosses who go ahead and steal money from the company for themselves. Gambling. If you're caught playing poker, bridge, or anything else for cash, then yeah, you can be dismissed. Now, gambling, in my opinion, shouldn't happen at an English center or at a school or anywhere anyways, just because of the fact that people lose money. You can spend money on better things than gambling. The only thing I like to do is maybe buy some lottery tickets, and that's it. And buying lottery tickets is legal. So just spend your money on lottery tickets, man. Deliberate infliction of injuries. This means someone who likes to go ahead and punch or hit other people, or, possibly do other stuff that's more serious. Or uses drugs at the workplace. Now, I don't have to tell you, don't be stupid. Don't do drugs. Don't drink. Now, for those of you who like to do that kind of stuff anyways, obviously I can't stop you. But if you get caught, that's on you. So just remember that. Now, clause 2. The first part, in my opinion, applies to, like I said, like Raytheon Technologies and Lockheed Martin and stuff like that. Doesn't really apply to English centers, but I'll say it anyways, or English teachers. Clause 2. The employee is dismissed for discipline, or the employee discloses technological or business secrets or infringing the intellectual property rights of the employer, or commits acts which are seriously detrimental or posing serious detrimental threat to the assets or interests of the employer. Again, that only applies to like very highly sensitive technology companies. Doesn't apply to English centers because everybody knows how an English center operates. Excuse me. But everybody knows how an English center operates, so there's really nothing secret about it. Not really. Especially not when you know as much as I do. Now, commits sexual harassment in the workplace, that against the internal labor regulations. That's pretty much self-explanatory. If you make anybody feel uncomfortable, then yeah, it's no good. All right? If you make anybody feel uncomfortable and they take it as a sexual thing, then yeah, you're done. Now, I'm going to go ahead and mention this. English centers are not dating agencies. They're not. All right? Do not hook up with your coworkers. Bad idea. All right? Because it's going to cause a lot of problems later on. And if they want to say sexual harassment, well, you got nothing that proves that it was or wasn't sexual harassment. Now, remember, sexual harassment against women and sexual harassment against men are the exact same thing. They are not different. Men and women feel the exact same when it comes to sexual harassment. And anybody who thinks otherwise is more than happy to contact me, and I will be more than happy to talk to you about it. Now, moving on. Clause 3. The employee repeats a violation which was disciplined by a deferment of pay rise or demotion and has not been absolved. Has not been absolved. So repeat violations means if you keep screwing up, you keep screwing up, you keep screwing up, yeah. So here's the thing. Again, 1 and 2, they must wait for the competent authorities to issue a decision before anything else can happen. Clause 4, the previous one, talks about these two. So, yeah, essentially, a repeat violation means a violation which was disciplined and is repeated. So you go ahead and say you steal once and you steal again before it's absolved in accordance with Article 126 of this code. So there we go. Now, number 4, the employee fails to go to work for a total period of 5 days in 30 days, or for a total period of 20 days in 365 days from the first day he or she fails to go to work without acceptable excuses. Now, I can go ahead and, okay, I'm sorry, I didn't read the rest of that, my mistake. Justified reasons include natural disasters, fires, the employee or his or her family members suffer from illness with a certification by a competent health authority, and other reasons as stipulated in the internal labor regulations. So essentially, if you fail to go to work and you get sick with a very serious illness and you have a certificate that says you're sick, like, COVID-19 or something like that, then they can't fire you for that. Now, I think this also could talk about like cancer and stuff like that, but not really sure. Anyways, so essentially, reason why I want to talk about this is because the fact that in my last employment contract for an English center, they said 3 days. Yeah, 3 days. Even though the regulations say 5. Yeah. This means for a total period of 5 days in 30 days. This means non-consecutive. So like within 1 month, if you have 5 days, either consecutive or not, of a person not showing up, they're done. Or for a total of 20 days, again, non-consecutive or consecutive, who knows, in 365 days from the first day he or she fails to go to work without acceptable excuses. Now, obviously, you can't do 20 consecutive days back to back because you're only allowed 5 days within a 30-day period. So if you do 5, 10, 15, 20, if you miss 5 days a month for 4 months, you're done. So yeah. All right, so Article 126, and I know I'm probably going to show both of these together, and that's perfectly fine. All right, so Article 126, because I want to hide this one, forbidden actions, until we actually get to talk about that. No, we can't actually because it's already up there. All right, cool. So Article 126, absolution of violations, reduction in the duration of disciplinary measures. Please pay attention to this. Clause 1, an employee who commits a violation that is disciplined by reprimand, deferment of pay rise, or demotion will have the previous violation absolved after 3 months, 6 months, or 3 years respectively from the day on which the disciplinary measure is imposed if he or she does not commit any violation against internal labor regulations. So 3 months, 6 months, or 3 years. 3 years is a bit extreme. I think that would only apply to, like, state directors and, well, maybe not state directors, but, somebody who's very high up. I think that's what that would go for. 3 or 6 months would probably be more likely what an English teacher would get. So, if you commit a violation and you don't screw up for 3 months or 6 months, then it must get absolved from your record. That means it must get scrubbed from your record. If they don't, then that's not good. And in my opinion, you should have the right to look at your employment record, because your employer should keep a record on you and what you do, if there's any complaints against you or anything like that. You should have the right to know that. Now, here's the number one biggest thing that I could ever talk to you about. Well, one of the biggest things. Article 127, forbidden actions when imposing disciplinary measures in the workplace. Remember, Article 124 tells you what is allowed. Reprimand, deferment of pay rise for up to 6 months, demotion, and dismissal. So Article 127. Forbidden actions when imposing disciplinary measures in the workplace. Now, when imposing disciplinary measures. Clause 1, harming the employee's health, life, honor, or dignity. Now, when imposing disciplinary measures, they are not allowed to harm your health, they're not allowed to harm your life, they're not allowed to harm your honor or your dignity. If they do any one of that while imposing disciplinary measures, it's illegal. Now, Clause 2 is literally one of the biggest things in this labor code that I could possibly ever show you. And this is the number one thing, I think, that no English center, especially the evil ones, would ever want you to know. Clause 2, applying monetary fines or deducting the employee's salary wages. Right there. So you know what this means? This means that they are not allowed to give you fines at all in any form. And remember, foreigners are protected under the Labor Code, Article 151, Clause 3. This means if your employer tries to give you a fine for something, it's illegal. If they take money out of your salary to pay a supposed fine from the company, you tell them you want your money back. If they don't give it to you, then you can sue them or, call the police and say, hey, my employer stole from me, I want my money back. And yeah, now if your employer or your English center tries to make a big deal out of this, just show them this video and tell them that I said this, okay? Now look, again, I'm not a lawyer. I'm not certified to practice law in Vietnam, all right? But I'm showing you the labor code in both English and Vietnamese. And again, the English one is for reference. The Vietnamese one is the one you really need to pay attention to. There is an actual book that is available for common citizens to buy called the Labor Code of Vietnam. And this is exactly everything that's in there. Now, moving on. So again, if they try to make you pay a fine, it's illegal. Any fine. So if you mess up and they want you to pay a fine, illegal. If they say, if they just off the top, they give you a fine because, oh, you were late. Oh, you didn't show up for class. Nope, not allowed to give any fines. So if your contract specifies any fines, do not accept. Flat out, do not accept if they mention any fines in your contract because it's not legal. And you can tell them it's not legal. And the proof is in this video. Clause 3, imposing a disciplinary measure against an employee for a violation which is not stipulated in the internal labor regulations or employment contract or labor laws. So if they try to impose a disciplinary measure against you for a violation that's not stipulated, it's illegal in the internal labor regulations, employment contract, or labor laws. So, yeah. All right, so Article 127. Please remember all this, all right? This will help you out. Clause 2. Now, work suspension. An employer has this right to suspend an employee from work. Okay, here we go. I guess we're going to talk about this too real quick. Work suspension. Article 128, Clause 1. An employer has the right to suspend an employee from work if the violation is of a complicated nature and where the continued presence of the employee at the workplace is deemed to cause difficulties for the investigation. An employee shall only be suspended from work after consultation with the representative organization of employees to which the employee is a member. Please pay attention to that. An employee shall only be suspended from work after consultation with the representative organization of employees to which the employee is a member. This means that if you do not belong to a union, as all English teachers, to my knowledge, don't, they are not allowed to suspend you from work. Again, just an opinion. Clause 2. The work suspension shall not exceed 15 days, or 90 days in special circumstances. During the suspension, the employee shall receive an advance of 50% of his or her salary entitled prior to the suspension. So you get half your salary for the 15 days or 90 days, whatever it is. So you get at least half your salary. Hey, that's better than nothing. Upon the expiry of the work suspension period, the employer shall reinstate the employee. That's provided, you didn't do anything wrong and that you can actually return to work. When the employee is disciplined, where the employee is disciplined, he or she shall not be required to return the advanced salary. Not be required to return the advanced salary if you're being disciplined. Clause 4, where the employee is not disciplined, the employer shall pay the full salary for the work suspension period. So, yeah. But I think this Clause 4 actually clashes with Clause 2 because it says, is disciplined or not disciplined? So, if you are disciplined, you don't have to return the advanced salary, but if you are disciplined, you don't have to return it. If you're not disciplined, the employer shall pay the full salary for the work suspension period. This is a little confusing to me, but I think that if you're not being disciplined and you're suspended for some reason that, you didn't do anything wrong, but they suspended you anyways for some reason, that the employer must pay you the full salary for the work suspension period. But again, remember, this only applies really if you go ahead and belong to a union. All right. But I put that in there anyways just because it goes on. All right, so we have about less than a minute left, so we're going to go ahead and talk about a little bit about the material responsibility. The reason why I want to talk about this one specifically is because of the fact that a lot of English centers will try to make you pay for stuff that you really shouldn't. So, here is what you need to learn about material responsibility. Essentially, if I could boil it down to a few simple words, I would say, if you break it, you buy it. If you get something in good condition, it should be returned the same way. If you get something and it comes back terrible, then you should go ahead and buy a new one. Plain and simple. Now, if they give you a, used copy of a book, they should have you sign and specifically mention that it's used, not new. So that this way, if anything bad happens, I think you shouldn't be charged for a new one. All right, so we got less than a minute left to talk about this before I go ahead and move on. I might be able to talk about 129 real quick. So Article 129, compensation for damage. Clause 1, an employee who causes damage to equipment or otherwise damages the employer's assets shall have to pay compensation in accordance with labor laws or the employer's internal labor regulations. In case the damage caused by an employee is not serious, not deliberate, and worth less than 10 months region-based minimum wage announced by the government, 10 months, so 4,865,200 dong times 10. So if it's worth less than that, then the employee shall have to pay a compensation of not more than his or her 3 months' salary, which shall be monthly deducted monthly deducted from his or her salary in accordance with Clause 3, Article 102 of this code. Remember, I already talked about that. So go look it up. All right. There we go. And time limit has stopped, so we can go ahead and try and get through this quickly. All right. So essentially, they can only deduct it monthly from your account and not more than 30%. So that's what it means. They can only deduct up to 30%, and that's it. Now, moving on. An employee who loses the employer's equipment or assets. Yeah, if you go ahead and lose a laptop or something like that, or consumes the materials beyond the set limits, means if you go ahead and use like 50 pencils when you should only use 3, then you shall pay a compensation for damage in full or in part at the market price, or as stipulated in internal labor regulations, or the responsibility contract, if any. In case this is caused by a natural disaster, fire, war, major epidemic like COVID-19, calamity, or another force majeure event, which is unforeseeable and insurmountable, and all necessary measures and possibilities for avoidance have been taken, the compensation shall not be required. So if any of that stuff happens and the stuff gets damaged or destroyed, compensation shall not be required, but only in those circumstances. Now, I got less than 4 minutes left to go, so we're going to go ahead and wrap this up, and in the next video, I'm going to talk about Article 130. So, let's go ahead and do this. It is less than 20, well, it's less than some minutes until midnight. But anyways, we're going to go ahead and move on. So, today I talked about crime and punishment, and here's the thing. A lot of English teachers don't know these rules. They should. Because I know a lot of English teachers that get stuff stolen from them all the time because of fines, because of being mistreated, because of not being disciplined properly, because of all these different things. You have English teachers here that are suffering because of these bad English centers. Not anymore, because I'm here. And yes, for all the English centers out there that really don't like me right now, honestly, you should have saw this coming. Because when you mistreat people for so long, and one of them actually finds your laws and learns your laws, and uses your laws against you to force you to act better, again, you should have saw this coming. So, if you like my videos, please like, share, subscribe, comment, hit that notification bell so you go ahead and keep updated on all my latest, videos and whatnot. If you wish to donate, please contact me through Gmail at tuxedoshadow@gmail.com, or you can use the Google Chat feature with my email address, tuxedoshadow@gmail.com on Google Chat. Also, if you wish to go ahead and join my Zalo group and you live in Vietnam, please follow the link in the description below. I will go ahead and say to you all, thank you, 12 subscribers. I'm so happy. Let's keep it going. Let's go ahead and stop the evil English centers once and for all.